rent-free in your heads again, huh? I mean, if you're gonna spend your days obsessing over me, you might as well start calling me something respectable. Maybe Daddy Shizzy, or better yet, Papa Nut. Who's the grown-up here? Alright, it's me. Let's go. Call me Daddy, yeah, that's who I am. Running your minds like a master plan. Papa Nut, Shizzy Daddy, take your pick. I'm rolling in your thoughts while you still act sick. Call me Daddy, it's what you mean. Why you chase the crust and I take the lead? Living rent-free, that's my name. Go ahead, say it, put some respect on the name. Man, I'm too old, well here's a surprise. I'm the one with the brains while you're stuck with the lies. You act like you're experts, but here's the reality. I'm the one controlling your mental reality. So while you're out there trying to throw shade, I'm sipping coffee and you're feeling betrayed. You're mad, I got the spotlight, now it's my time. So why not call me Daddy or Papa with a rhyme? I'm the landlord and you're just the tenants, stuck in your headspace with no insight, no repentance. Call me Daddy, you know it's true. You'd be lost without me, stuck in the glue. Call me Daddy, I'm holding your mind while you're scrambling, trying to find what's behind. Papa Nut, Shizzy Daddy, don't you see? You're living in my world now, I'm the VIP. Call me Daddy, just let it be. While you're trying to figure out your own identity. Oh, I see you're confused, trying to get it right, spinning your wheels while I'm out of sight. You think you've got it figured, but you got it all wrong. I've been running your minds all along. But sure, keep pretending you don't care. Keep saying you're done, but I'm still in the air. You got no choice but to bow to my name. Daddy Shizzy is here to own the game. You say you don't watch, but you're obsessed. Every word I say puts you to the test. Call me Daddy, Papa Nut, you know you should. Because I've been living rent-free, and you know it feels good. Stuck with Daddy for life. I'm Papa Nut, Shizzy Daddy, owning your headspace, and there's no escape. Good luck with that.
And greetings. How are you doing? Hello, folks. Hello, hello, hello. My, oh my, what a beautiful evening we have going on tonight. All kinds of stuff. Oh, shit. I've forgotten I said anything. Oh, wow. Where's the rent usual? Says, I don't know. Who doesn't? I'm pretty sure I got everybody there. Got everybody there. Good to see you. Good to see you. Oh, yeah. Good stuff. You know what? There was something I was looking at earlier. I realized that they were locked on here and they shouldn't be. Give me just a second so I can get this taken care of. I don't think I saved it. Let me double check. Oh my, oh my, oh my. Let me double check this. I don't think I saved it. And where was it? Yes. There. And I want to say that it's here. No, they should be fine. And there. Okay. Yeah. There we go. I think I got it. I think I've got it fixed now. That should be better. All right. Hey, Just Don, how you doing? Good to see you. Good to see you. Man, beautiful evening. It is indeed a beautiful evening. I hope that you guys have been keeping up with a little bit of the news that's been going on. But, you know, if you haven't, well, it looks like someone didn't show up to court like they were supposed to today. Interesting. So it got dismissed. Which means that another case is going to be moving forward. And then, of course, there's the silliness of old Saran wrap over there that hasn't figured out what dates he's supposed to be doing things. He still haven't figured out he's in 2026. Oh my gosh. Hey, Valor News Parody, the greatest news parody. Good to see you. Good to see you. And then, of course, we've got the fun stuff that we're going to be talking about here in a little bit. Wait, what? 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 Are you wondering, huh? What? Are you wondering what that means? Wait, what? Well, give me a second. I'll pull up that document. It's quite interesting. Let's see here. We've got that document here somewhere, and also it looks like Jeremy has filed his appeal, or started filing his appeal, and it's begun. So that one's moving right along. And then, of course, in this one here, give me just a second. I'll pull it up if I got the right one. No, I don't have the right one. So and it was ABC right here. And this one here, I just want to make sure that I've got it pulled up. Oh yeah, there we go. That's the one. Why is that so small? That's what they all say. Why is it so small? I don't know, man. Maybe blow on it. I don't know why. What? Oh, I'm sorry. Am I live? Oh my gosh. Yeah. So it looks like there was supposed to be a conference today, and of course that didn't actually happen. The conference did, but they could have argued a reason to keep this in court. Cancel that. Why is it not showing up? Oh, I know why. Let me go ahead and go into my layers there and remove. This is right here. Move that. Doggone it. Move that there. There we go. All right. So there it is right there. So in the Circuit Court of the 9th Judicial District in Orange County, Florida, case management conference, court minutes, 8:41 in the morning, 27th day of January 2026, via audio telephone conference. This case came before this day for ex parte Honorable Sandor Bryan presiding. Libs is supposed to be there against ABC Legal Services, and guess what? Court reporter was there. Court deputy was not available. Parties via Zoom. The plaintiff failed to appear. Attorney Amaris Gibi, maybe, appeared on behalf of the defendant. The court rules as follows. The court dismissed this case without prejudice. Court recess at 8:43. On this, the 27th day of January 26, subject to call filed in open court on 1/27/2026. And the Office of Tiffany M. Russell, Orange County Clerk of Courts. My, oh my. Yes, you should have showed up. Oh, well. just like that, it's done and over with ABC. All the whining and crying, and they're stalking me, they're harassing me, mental abuse. Oh. They said, nope. It's done. It's done. It's done. There you go. Of course, they'll say, well, Shizzy shouldn't be reporting on this. It's felonious. I should change my name to Felonious Shizzywhiznut, whatever. We'll get to that one later. But let's get back into this document right here, and we'll have a little bit of fun. We'll just have a little bit of fun. Keep you in your shoulder pain. Oh, just on. It hurts me to think about that. I told you, man. Don't body check Levy. You try doing that, you're gonna hurt something really bad. Oh, I hope you're okay, Valor. Did you have an accident in your truck? Ah, that sucks. That sucks, brother. No fun. All right, so we'll get on with this one here. Man, my eyes are feeling all blurry today. I've been getting sicker and sicker, I think. We'll see. We'll see how we do tonight. Ah. Oh my. Oh my. Let's see. Did I miss something? You report on what you want. Of course I do. I report on anything that I want to. Okay. Yeah, so okay. Let's see. Okay, we're done with exhibit 77, correct? Question. Yes. Okay, one moment. I thought you were referring to the paragraph. What exhibits did you want me to pull up? 74 for now. Okay, I do have 74. Okay, is that your responses to admission? What's the title? It reads responses to defendant's first request for production of documents. Oh, I'm sorry. Look at 75 then. I need to find admissions. It could be 75 or 76. Exhibit 75. I do have it in front of me. Oh, thank you. So admission number 1, you indicate that you can't give the names of other people who saw the defamatory road signs, but that you can identify them by other manner of identification, correct? Mr. Shockett, objection to form lacks foundation, but you can answer. Is that correct? As I read, no objection. I read number 1, it says admitted as to names, denied otherwise. Okay, so when you say admitted as to names, you're admitting that you can't name anybody who saw the road signs other than the 3 individuals, 2 Grangers, and Zim Paget, correct? Same objection to form. Why are you looking at your lawyer? Because he objected, I need to know if I can continue or not. You can answer. Okay. So are you able to give any names of anybody besides Stephen Granger, Therese Granger, Zim Paget, who saw the signs? Can you clarify your question? Are you in regards to the signs posted in the ground around Otter Creek, or just saw the signs in general? Because, yes, so I'll clarify. Can you give the names of any individuals who saw the signs while they were posted at the ground before they were found by Stephen Granger, Therese Granger, impacted my places? Stephen Granger, Therese Granger. I dreamed you were in the pics of my truck. That's scary. Oh, you DM'd me. I thought you. I'm sorry, man. I'm telling you, my eyes are blurry. I thought you said you dreamed of me with pics in the truck, but I get it. You DM'd me the pics of your truck. Okay, I got it. I was like, why is he dreaming of me in pics in his truck? That's a little weird. Feeling all dirty, yet turned on, sort of. Stephen Granger, Therese Granger, Zim Paget. Other than that, I have not had anybody else share with me. Okay. Now you say that though you deny otherwise, meaning you deny that you're unable to identify people who saw the signs by another manner of identification by name. Objection. So what other manner of identification are you going to employ to show other people saw the signs? Objection as to form, competency, you can answer. I don't understand the question. How are you going to prove that anybody saw the signs while posted in the ground other than those 3 peoples? Objection as to form, competency also calls for attorney work product. You can answer. I think number 1, common sense. There are major roads, and there have been many studies done on those major roads in regards to whether Otter Creek needs a light or not. And those studies are all public information. So the aspect that people were driving on roads, common sense tells you it's a road. People drive on it, and people saw it. And not only is it just a road, it's a very heavy traffic. It's very heavy traffic in the road. And so traffic studies. Can I please finish? I'm limited in time, Mr. Hales, and you said traffic studies, and that answers my question. So my next question is, can you name anybody by name, an individual you can certainly say cars drove by, but can you identify any other person than Zim Paget, Therese Granger, or Stephen Granger that saw the signs as they were posted? Yes or no, Mr. Mann? If anybody else comes forward, I will name them. Oh, thank you. Admission number 2. Can you read out loud the question and your answers? I don't have a question. Oh, it's not listed, is it? Which is part of my confusion in your question on this. I don't have it. That's because your counsel didn't write the admissions above the answer. What other publication do you know of, if any, of the defamatory road signs by my clients? Can you please restate the question? Other than the signs being stuck in the ground, are you aware of any other publication? Yes, I'm aware that Lynette Preston has posted online on Facebook that she didn't post signs. John did. I'm also aware that John Cook, in his Ohio court hearings, which he was found guilty for stalking, stated that what's it matter if Lynette posted the signs? What's that have to do with me? I also know that the signs are posted, pictures of the signs are all over the internet. Wow. Did my clients put pictures of the signs on the internet, or did you put pictures of the signs on the internet? That's in regards, are you asking in regards to Lynette and John? Do you have any evidence that my clients posted the signs on the internet? Yes or no? Can't recall currently. Thank you. Number 2. No, number 3. The question was, did your reasonable inquiry, Mr. Mann? My question is, what did your reasonable inquiry and review of the readily obtainable or known information consist of? Objection as to form lacks foundation. You can answer. Can you restate the question, please? I need to move on from that question. You admit that Zim, Paget, Stephen Granger, and Therese Granger don't believe that the statements on the signs correct. You admitted that in number 4. Correct. Nevertheless, you weren't willing to admit that the Grangers and Paget know the signs were false, whereas you admitted that Deanna West knows that signs were false. Objection. So what's the difference between Deanna West, who knows the signs were false, and the other 3 individuals that you weren't willing to admit know that they're false? Again, I don't understand your question. If you can ask a clear, concise question, then I would be able to answer it. That's okay. I'll move on. Okay. All right. Now, you identified 3 contracts as being interfered with. Olite, Facebook, whatnot, correct? Are you referring to Exhibit 75 again? I'm asking you right now, sitting here, not referring to an exhibit. Are you? Is it your testimony that my clients interfered with Olite, Facebook, and whatnot contracts? Yes. Do you have an actual contract with Facebook? Yes. A written contract? The terms of service for monetization is a contract. I've attempted to try and retrieve that, but most of those are public information. So when you sign, there's not where I can terms of services. So I can't just go in and print off of Facebook. I got you. But you terms of service for monetization, correct? You've agreed to terms of service, but you didn't have an actual transaction with lawyers to sign a special contract. Anybody could do what you did. Right. They do it. And, but you have an actual contract with whatnot? Yes, I do. All right. And you claim that my hair clients, I heard Shizzy say so, probably say, hey, brother, good to see you. Welcome, sir. All right. And you claim that my clients interfered with that contract as recently as a week ago. Your clients, what did they do a week ago, Mr. Man? As recently as a week ago, your clients and those supporting their efforts to destroy my life and my business and my relationships have gotten all of my links to my whatnot options taken off YouTube. And that is my primary promotion for my whatnot options. My client got your whatnot links taken off of YouTube? Yes. My clients contacted whatnot and said, take Mr. Jeremy Hales' links off of YouTube. Your clients in your anti-what the hell's media ecosystem have. Do you have, could I please? John Cook, answer. Hold on, listen, you can't let him, if you're going to ask a very open-ended question, you're going to get long answers. The question, do you have any evidence that John Cook contacted Whatnot directly? He is providing you with whatever his answer is as to what the evidence is. Mr. Shockett, may he be allowed to finish the initial answer? Court, go ahead. Your clients and the Anti-Hale's eco-media system have very openly stated to report everything, take him down, get him removed, and report his Whatnot, report his options, report on Whatnot, report YouTube, report Facebook, report to the point where YouTube did remove all my links to my options based on the reports of the Anti-Hale's media ecosystem, which is my main marketing towards my options, which is supplementing my current loss of income on YouTube and Facebook, which now I'm going to lose income on Whatnot as well due to it. And this is really important because what he's said here, and he's said this multiple times over the course of quite a few things, is saying, hey, look, you know, this is how we market our stuff is on YouTube. And we have seen the whole little Anti-Hale's group over there talking about, well, if you see something, just mass report it. That's not appropriate. You don't need to tell people to go out there and mass report stuff. And that's going to come back and bite them in the ass at some point in time. And well, they just can't stop. They've got some pretty big issues. Yeah, he's talking about the auctions. I think that's what he's talking about whenever he's saying options. Whenever they're putting in options, I think he means auctions. But of course, you know, the court reporter may not know the difference. Hey, Omaha, may I have a happy birthday? Turned 73. I do love your voice. Well, let's see. I think I can make that happen. Give me just a second. If he can't make it, I can make it here for him. Give me just a minute. I will do this. Oh, doggone it. Sign in with YouTube's. And that one there, I had to do some clearing of my computer cache because it was having some problems. And continue and continue. All right. And let's see, we will go to and I think here, paste, and I think that will do it there. And then we're going to go like speaker. Give me a second. I'm having a little bit of fun here. So, all right, I got it. And there we go. And let's do this. We'll do that there. Oh, there we go. And send.
Hey, Jean Martin, I know it is not the same, but happy birthday to you. Hope you have a wonderful day.
Did you like that? I know it'll take a few seconds for you to get that. Was that a little bit good? I mean, sometimes I can be good. Oh my gosh. Wonderful, wonderful, wonderful. Break up the craziness. I love it. And I'm not sure that it pronounced it correctly. I think it's Jean, but it could be Jean. Oh, excellent, excellent. Well, you know, we do what we can here, and most definitely happy birthday to you.
Oh my, happy birthday to you.
Happy birthday to you. Happy birthday.
It is your day. Happy birthday to you.
Oh, yeah, love it. Love it when people have birthdays. Just one of those nice, easy kind of nights. One of those really easy, nice kind of nights. All right, let's get back to this one here. Okay, so question. Do you have any evidence that John Cook made direct contact with Whatnot of any kind at any time? I will contact Whatnot and find out who contacted them. Do you have any evidence that Michelle Preston contacted Whatnot, Mr. Man, directly at any time? I have evidence of your client saying report everything that I do, which we actually looked at in your exhibits earlier here this morning. Do you have any evidence that Lynette Michelle Preston directly contacted Whatnot? I will contact Whatnot and find out if she did, but that's not the issue we're talking about. We're talking about the issue with YouTube. Now question. Court, you answered the question. Yes, sir. And Mr. Deuce Manskin, you're about 15 minutes. Oh, thank you, Mr. Court man, Mr. Judge. Let's say, so you're not claiming any other contracts were interfered with besides Whatnot, terms of service of Facebook and alike. There was no contract with Olight. I'm claiming that income has been drastically affected. So while I have no contract with Olight, income is affected based on that. While I'm still in contract with YouTube, income with YouTube has been drastically affected based on these things. And you have an outside contract with YouTube, not just the terms of service. Terms of service. Understood. If you had any direct communication from Mr. Cook or Miss Preston threatening you unless you give them something, you will have produced the correct objection form competency. You can answer. Do you understand my question? Can you restate the question, please? Rephrase it. Can I expect that you have produced any direct communications from either Mr. Cook or Miss Preston that you threatening you unless you give them something? Same objection. You can answer. No response. Are there any others out there that we're not aware of yet because you didn't produce them? There's nothing else out there that I'm aware of currently, but there's more coming daily, meaning you're going to continue your daily canvassing. You're going to be watching my clients like a hawk. Last night was over 5 hours worth. Look at Exhibit 101, please. And if you look at paragraph 15, I'm sorry, it's not Exhibit 101. It's your affidavit dated March 26, 2023. We were asking questions about it earlier. I think it's 101, 71, I think, or 100, maybe. 100? 100. Oh, I am so confused. And if you look at paragraph 15, it talks about a cease and desist letter, correct? Correct, page 3. Yeah. Exhibit 101, or excuse me, 100 with a scratch in the last 0. Yeah. Yes. And does it reference a case and decease A cease and desist letter in paragraph 15? Yes. Does that there cease and desist letter quote any specific defamatory statement? You might not have it, but I'm going to show you Exhibit 10. If you could look at Exhibit 10, which is the cease and desist letter, it's there any specific quoted defamatory statement within Exhibit 10. She destroys. You're killing me. Counsel, I need time to actually read it. It's referenced in paragraph number 5. It's come to our attention that you posted defamatory statements regarding Jeremy Hale's. Slow down, please. I apologize. I'm sorry. Okay, I see what you're referring to. Is come to our attention that you posted defamatory statements regarding Jeremy Hale's on various web pages, including but not limited to, etc., as well as other social media platforms. My question is, there quoted defamatory statement within that paragraph? No, there is not. Okay, now this cease and desist, it demands removal of all postings. Am I correct, Mr. Man? All postings, it says. Can you refer me to the paragraph you're referring to? B, in the third from the bottom paragraph, it begins with, we demand that you immediately, A, B, and B is part of, I'm asking about, immediately remove and delete all postings related to Mr. Hale and his interests. Do you see that? Yes, that's what it says. Okay, now that doesn't qualify. The demand is referring to just defamatory postings, does it? It does if every one of her postings about me is defamatory. If every one of his postings about me is defamatory, I can assure you they didn't say anything pleasant. So in other words, your testimony is that the demand to remove all postings is because all postings are defamatory, not because they were just being, the cease and desist was being indiscriminate. Is that correct? Yes, sir. Can you rephrase it? Yes. To a natural question? But your testimony, yes. The reason that this cease and desist demands that you remove all postings is because your testimony, all postings being made about you are defamatories. No, my testimony was objection to form, competency. You can answer. My testimony was, if all of their postings are defamatory, then it catches every single one of their postings which are defamatory, which they have nothing nice to say. Now, in regards to you, can I please answer the question? In regards to your question about why it's posted that way, my lawyer who drafted this drafted it that way. I can't answer why he did that because I'm not him. Okay, so is it your testimony that you know that Mr. Cook and Miss Preston never made any posts about you that is non-defamatory? No, that's not my testimony. My testimony was if it was a yes or no question. Your Honor, if I ask a yes or no question, I should get a no answer. Let him answer the question. Then you can come back and ask him for a yes or no. So I'll move on to the next question because this is going nowheres with me. Has there, to your knowledge, ever been any follow-up to this letter from Stanley Griffiths or anybody at his firm to my client? Yes. And what was that follow-up? Well, Lynette called Stanley Griffiths, and Stanley Griffiths' communicator listened to, in his words, Lynette Preston for over half an hour, yell and scream at him over the phone. And was there any follow-up after that? You're asking in regards to Stan? I'm asking, you're right, whether your retained counsel, Stanley Griffiths, did anything other than send a cease and desist. You're about 5 minutes. No. The follow-up was when I was in Ohio, I finally hit a breaking point with what they were doing and saying, and I filed for civil protection orders against them. In paragraph 16, you mentioned that the signs were posted all over Otter Creek, but in the complaint you wrote they were posted around the roads surrounding Hale's property in Levy County, Florida. So my question is the second description more accurate that the signs were posted around your property? Are we referring to another exhibit? Where are we? Paragraph 16, exhibit 100, Same exhibit. Okay, I'm there. Yeah, so that paragraph, you say that the signs were posted and all over Otter Creek. In the complaint, Mr. Man, you describe it as around the roads surrounding Hale's property in the Levy counties. So would that second description be more detailed? You're not saying that the signs were posted far away from your property, but only near your property, right? The signs were posted all over Otter Creek. Otter Creek is a town of less than 100 people with 2 major highways. Yeah, but you said around your property. You asked him where else they were posted. He's answering it. Go ahead and finish where else they were posted. All right. Otter Creek has 2 major highways. That would be Route 19, which is also called Route 98 and Route 24. While I own property on Route 24 and right off Route 19 and 98, they were posted on Route 24. They were posted on Route 19, 98. They were posted downtown Otter Creek on different roads. So they were all over Otter Creek and near my properties. Okay, which Otter Creek is small, so the aspect of detailing and describing Otter Creek around Otter Creek or around the properties, I have more property than anybody in Otter Creek. Otter Creek is very, very small. Both descriptives are true. Yes or no? Do you have any photographs of the signs as they were found in the ground? Yes. How many? 1. Okay. In paragraph 19. In 19, you write, Mr. Cook, Miss Preston online posting called me a child predator are consistent and ongoing to this day, correct? Correct. What online post calling you a child predator are you referring to most recently to this day? Well, there was an entire live stream last night calling me a PDF file for over 5 hours that you were a part of, and so were your clients. I'm going to put, so to this day, which went past midnight into this day, which is posted online on YouTube currently right now, this day. Are you referring to any Facebook posts? You asked me online posts, so Facebook, YouTube, all of the social media platforms are online postings. Okay, and YouTube was last night and this morning to this very day. You identified last night's YouTube stream. Are there more recently before that? What would be an online post calling you a child predator? I would have to go back and look. There's so much information for me to go through. And then if you would have prepped me for this question, I could have been better prepared. And then you state their behavior is escalating. They're harassing me in Ohio and in Florida. Did I read that correctly, Mr. Man? Which number are you on, please? It's 19 or 20. You have 2 minutes. Can I have the exact number? No, I'm going to move on to the next question. May I have an extra 5 minutes? I just found it on 19. Your Honor, you have until, we're right at 12:30. You can go into 12:35. That's it. I appreciate it. It starts with their behavior is escalating. I found, it starts with their behavior is escalating. I found it in 19. Yeah, so they're harassing me in Ohio and in Florida. There's something other or more recent in Ohio than that email. Exhibit 78 to the mayor's assistant. Well, the aspect of online harassment has no boundaries in regards to states and countries. So what specifically, can you rephrase the question? No, I'm moving on to the next question. I'm starting to panic. I'm starting getting me the cold man sweats. Exhibit 101. Well, Exhibit 102, please. Exhibit 102. Could you read out loud the text beginning with our haters and skipping the timestamp? Our haters can't stop talking about us even when they have legal documents in their hands, even when they continue. No, they're going to be sued, even though they know they're going to lose everything in a lawsuit, because a lawsuit isn't to win a lawsuit. It's to make you spend all your money on a lawyer and bankrupt you. That's what the win is. I could care less if I win in court. If I win in court situation, my goal is to make sure you have no money. That is the goal of the lawsuit. And what they do, what do they keep doing, talking about us? Okay. Now I created this exhibit from May 21st, 2023. What the hell's live stream of which the link appears? Do you doubt the accuracy of my cutting and pasting of what you said on that date? I do doubt it because I speak in complete sentences. Mug raid, welcome Mug Raiders. Okay, but I do think that you used AI transcripting, which is often wrong. Okay, but the context is there. And Exhibit 101, could you read that out loud? December 8th, 2024, live stream on that umbrella guide. Do you want me to read the link? Yes. No, I don't want you to read the link, just the text. Okay. Guess what, the magistrate? Now you know what. I'm not going to share that yet. I apologize. I went down a road that wasn't fair. Well, I will share this. Magistrate is well aware, and the magistrate has told us to file a motion against him for sanctions. From the magistrate's own mouth, file a motion against sanctions. He will bring him here to Pensacola and he will rule on it. So all these things that he has done to the magistrate, it isn't pulling any punches. I can't read that, and Crook will have to be in Pensacola. Okay. Can tell you some people inquired as to whether you had a direct communications with the magistrate based on this, but what's not what you were trying to convey, was it? Of course not. No, the magistrate. My counsel emailed the magistrate, and my counsel shared with me that the magistrate emailed him back, and he shared with me what the magistrate emailed him back, and I shared that publicly, that we were to file a motion, and if he need be, everybody would be brought to Pensacola, and looky, here we are. Okay, but you did put your own mouth. That's the word you use. Put what? Mouth. From the magistrate's own mouth. An email would be communication from the magistrate's own mouth. Now I can't confirm that this is 100% true because I don't remember. I do so many videos and live streams, but I will say that AI transcribing is not reliable, but I will also say that I don't push the context of this. I have shared that the magistrate told us through email, file a motion. My counsel shared with me, we're going to file a motion and we need everybody's coming here to Pensacola. And here we are. Mr. Hales, people who follow your channel and content, they can form opinions about you, correct? Oh, yes or yes. No. And they're free to voice those opinions either orally or in written form. Yes or no. Yes or no, correct? They are free under the extent of the law. So you may have freedom of speech, but there are consequences when you break the law with that snitch. And they're free to voice their opinions. You have 2 minutes, Mr. Manskin. Excuse me? You have 2 minutes. And they're free to voice those opinions within the confines of the law, whether they're favorable or unfavorable about you, correct? As long as it doesn't break the law. And they're allowed to articulate them, whether they're positive or negative about you, correct? As long as it doesn't break the law. And whether they're comments from a fan, from a hater, correct? As long as it doesn't break the law. Have there ever been other people who have made defamatory statements about you in YouTube chats or Facebook pages? Yes. Have you saved them? I'm in the process right now. We just amended to bring more, you being one of them. Have you ever come into possession of other private messages that the sender thought was confidential, but you got to see them about you? Please rephrase your question. I'm stuck on the that's all confidential part of it, because confidential, you send anybody to anything, it's the end of it. It doesn't matter. It's never going to be confidential. You're a public figure, correct? Yes. And so public figures are what? It comes with the territory to have people who they don't know say things about them, correct? Objection to form, competency, you can answer. Again, anybody can have opinion about me. They can go, Jeremy's good looking. They can go say he's the ugliest thing I've ever seen. I love him. I hate him. That's all fine to the extent of the law. And as you said about your own client, Lynette Preston, she's a celebrity now. Once you're a public figure, it's going to happen. I don't care about any of that. I care about it when it's defamation and destruction of my business, my personal relationships, my life. That's the illegal part. Last question, Mr. Manskin. You just called Miss Preston a celebrity? No, you called her, Miss Preston, a celebrity in writing form, which I have that. Have you ever used the name Tony Ristano? That was your last question? You're out of time. Time has expired. Mr. Shockett, I have no questions. We'll read. Court. Okay, so wrap up the way you normally would with the deposition with the court reporter. Yes, may I do a short summation? I don't want to presume. Whatever you would normally do if you were in a deposition. Yeah, okay. So we're done with questioning today. I believe you haven't identified any false statements that you show can cause damage, or any single statements containing an extortionate threat are identified in single customers lost due to interference with my clients. I have no more questions, okay? We'll read, no questions. Did you say you're requesting read? Hey, maybe not. Thank you so much. We'll get that song out here for you shortly. Did you say you're requesting read? Requesting read 30 days, counsel? There? 30 days? Oh, sure. Anything further that we need for the court reporter? Yes, sir. I need any orders. Are you ordering the transcript? Deucey? Yes, sir. Mr. Shockett, we'll take a copy. Any special format? Just the regular with a mini in the glossary, the word glossary. Mr. Shockett, digital only. Oh, me too, digital. I do not need a hard copy. I get enough hard copy that you can feel. Okay. Only by emails. And the exhibits attached digitally. If that's the process, yeah. Okay, and reading and signing through you, sir, Mr. Shockett. Sorry, reading and signing through you? Oh, yes. Sent to your office? Yes. Okay. Are you the same court reporter that did the other deposition, the same company? No, same company, yes. Okay, whatever you guys did that way, just go ahead and do it. That's fine. Okay. Anything further for the court reporter? Do you need anything else? If I need any spellings, can I contact the attorneys? Oh, sure, because I am a great speller. Better than Leps, man. She can't spell worth a damn. Court reporter, thank you. Mr. Shockett, sorry. If I need any spellings can I contact the attorneys? Absolutely. Thank you. All right. So the court reporter, we're done with that part of that. You are free to go. The deposition concluded at 12:39 p.m. Yeah. All right. Let's get a little bit of music here. A little bit of jumping up and down for joy. A little bit of cheering that one is done. Hooray! But there is one more coming up. There is one more that's going to be coming up. Oh, yes, there is. But let's get this. Let's get this one here first.
Welcome to the shit show.
Oh, yes. Every single day. Maybe not. With 10 gifted memberships. And Deborah Peterson got one. Thank you. Shelley Green. Deborah Young. Got lots of Debras in here tonight. She Nemesis. Melissa Dowdy. Sam Buttery. Another Deborah Hudson. Ingo Routine got one also. Graham, Foxy, and Wildcat Luna. Devil Shire also got one. Good to see you. And, it is always appreciated. Those are always appreciated. And it's not just me that appreciates them. It's all the fine folks out there that might be hanging back and going, oh, I'd love to have a membership. They get those memberships, and it's like this neat little gift that they get. It makes them very happy and excited. And they get to see all the free stuff the members only stuff. So if you're a new member, you get to see the new video before anybody else does. If you're wondering, what video would he ever be talking about? Maybe you're saying the shitty website has a new video. Oh yeah, I have a new video. But it's the song that really matters. That's the thing about it. The video's there just for eye candy. Or not so much, but it's there for the for the fun. This is the latest song. Doggone it. So, of course, like I said, it's going to give me a hard time because it is being most difficult it can be. Give me a second. I'll pull it up here. Library. Go to. Why does it always do that? I don't want that. Right there. And I know workspaces, and it should be right here. Yeah, this one right here. There it is. And we will get that one up for you. Just give me a second. I want to make sure that we got the right thing. Yeah, I just go here and then I go this way. Share this. And why is it being difficult now? Why? Stop that one and share this one. Share that and do this, do that. And then we get to play the newest song on the list. But you get the song, but not the video. So don't get too excited.
No camera on, just a breathing mic. Static wheeze, then a midnight fry. Ellie be home, grease in the air. She hits the stream alone, nobody there. She's running to the chair like it owes her money. Skin on skin, only baloney, sweaty tube chins, harmonizing with she in hair. Stands like a leak blower, choking on nails. Grease goes cream to the carpet bow. Everest smells like sport the Nile. Keyboard shining, keys won't flat from raised type of lies and eating through cats. Paper play bros, all the poetry crimes. Came folded up like a greasy shrine. She smacks her lips, talks through teeth. Truth drown slow beneath the grease. Greasy jaw and no regret.
Crunch out enough to stab her down.
Smoke thick like a brain they fall.
Chicken skins and cigarettes.
Even the cricket left in
It
distress.
is not over at all about the music.
Ashtray overflowing looks like a storm. Filters crushed like boundary stomp. She flicks one round, likes another wrist route. In the mix she's never met.
Oh, brother.
Grease slides wrist to the elbow bend. Shirt stretched in, wipes hands again. Burps mid sentence, keeps on going. Hate gets louder the less she's known.
Chicken skins and cigarettes.
Greasy joy and
No rebate.
a dog bows down a hall. Smoke so thick the thoughts just stall.
Chicken skins and cigarettes.
Cricket packed up, said screw this and left. Catch his breath while climbing stakes. Grease is popping out of frame. Yeah, they all lies. Static laugh, she hacks and stays. Grease is stand step beside the mic. Evidence over beers and nights. She all just swallows, clears a throat. Them flies off a bullshit quote. Planes with seashells, none just sound. Confidence loud, facts drown. She chews, harder is a bullet. She slurps and sucks down the gullet.
Chicken skins and cigarettes.
Grease and joy.
No regret.
When you hack my clips, all of your red. Smoke so dense it kills the thread.
Chicken skins and cigarettes.
Even the silence sounds upset. Oxygen then weaves between each word. All glums like it's filing a grievance heard. Axe call slow on bleeds with hands. She wipes them off on her head. Lips smack, cough, swallow, lies. Same sentence, different fry. Room smells like burnt fat and spite. She hacking, coughing through the night.
Chicken skins and cigarettes.
Grease and joy.
No rebate.
I touch it like bone in a trash compactor.
Grease so addicted, need your lecture. Chicken skins and cigarettes.
Chicky laughing no.
Yeah, can't help this split. Chicken skins and cigarettes. Crazy joy and no regret. When you're blown like a dog don't fail. Smoke so big the balls are more. Chicken skins and cigarettes. All in and that's all get tech to stress. Smoke hangs low where the sitting cries. Grease still warm, truth still lies. Heartbeat thoughts with the detector. Red lights blame like a bad brain. She won't shut up. Oh, she telling secrets she don't know. Last drag burns, lungs protest. Skill chewing through the grease and mask.
Chicken skin and cigarettes. No regret. No regret. No regrets.
No camera.
Oh, that is such a fun song. I will tell you, it is an absolute blast. It was so much fun to do. I will tell you. Be right back. Need medical? Go get some medical taken care of. Maybe not. Be safe, Mister Whatever. Yes, that is me, Shizzy. Whatever. Very catchy, good music editing done. Can I join finally? Hello. I'm going to need a smoke after that one. Might just need one. Though. Oh my gosh. Let's get the next one up here now. You know, people were wondering, like, whatever happened to Jeremy? You know, what happened with Shockett? What happened with Jeremy? Did, you know, there was a sanctions hearing, and this has already been read before, but I think it's a good time to read it again. And it is going to be right here. And I've got that, and we will share the screen with you guys just so you can get this particular one. It is right there. All right. So this one here is a transcript of proceedings, show cause hearing before the Honorable Zachary C. Bolitho, United States Magistrate. Randall Shockett. Also present was Jeremy Hales. And also was Heidi, that was the official U.S. court reporter, in open court. So it wasn't closed court proceeding like a lot of people think. The court says, thank you. You may be seated. Well, good afternoon, everyone. We're on the record now in the matter of Hales versus Preston and Cook, case number 124CV45. Counsel, please make your appearances. Mr. Shockett, may it please the court. Randy Shockett, Shockett Law Group, Trenton, Florida, on behalf of the plaintiff. Jeremy Hales, court, good afternoon. Mr. Shockett, good afternoon, Judge. So the case is on the docket here today for several reasons. First, there is a pending motion for sanctions filed by the plaintiff, which was docket number 96. And in that motion, the plaintiff sought, among other things, revocation of Deuce, defense counsel pro hoc vice status in this case. And second, and relatedly, the court issued a show cause order, which is docket number 98, requiring Deuce to show cause today as to why his pro hoc vice status should not be revoked. Then third, March 27th, 2025, in docket number 118, the court ordered counsel for both parties to be prepared today to address whether sanctions should be imposed for their repeated abuse of the judicial process, filing of frivolous motions, and overall unprofessionalism. And the court's order, I specifically referred counsel to four motions. First, there was the defendant's motion for reconsideration, which is doc 78. Second was the defendant's motion for reconsideration, which was docket 82. Third is plaintiff's motion to dismiss counterclaim, which is docket number 85. And fourth is plaintiff's motion to dismiss counterclaim, which is docket number 86. Obviously, Deuce is not present here today. The hearing was noticed on March 14th of 2025, and Deuce was clearly aware of his obligations to be here today. Yesterday, he filed a notice informing the court that he did not plan to attend this hearing. The court issued an order yesterday afternoon stating that the hearing would go forward and refusing to excuse Deuce's attendance at the hearing. He was required to be here today and obviously is not. Mr. Shockett, you may not be aware of this because it just happened, but shortly before I took the bench, I received a notice. a motion to withdraw his counsel from Deuce, which is docket number 126, where he seeks to leave to withdraw from his representation of the defendants in this case, but pursuant to local rule number 11-1H. An attorney who has entered an appearance in a case must have leave of the court to withdraw, and the court must grant that. So the court has obviously not granted that motion to withdraw, and so Deuce still remains counsel in this case at this time, and has no excuse for not being here today. But that willful failure to appear by Deuce is not going to prevent us from going forward here today, at least in part. The hearing wasn't scheduled. It was scheduled for a number of reasons, as I mentioned, and one of those as to why to allow counsel, Deuce, to show cause as to why sanctions should not be imposed, including Deuce's case, the possible revocation of his pro hoc VJ status, and this hearing was designed as an opportunity to provide him with the ability to be heard with respect to those issues. And just to be clear, the purpose of the hearing is for the court to decide what action it is going to take. The court has not decided what action it's going to take, and that's why the hearing was here. It is for the court to provide the parties with the opportunity to be heard. The law requires notice and an opportunity to be heard before the court takes action, and today was scheduled as the notice and opportunity to be heard. Oh, sorry, I previously provided the notice, and today was the opportunity to be heard. I'm going to repeat myself over and over again. And given Deuce's absence, I can't hear from him regarding whether sanctions should be imposed against him or whether his pro hoc VJ status should be revoked. I will separately address in a written order the issue of sanctions against Deuce Manskin and the issue of his pro hoc VJ status. And since Mr. Shockett is here, well, I'm going to turn to you, Mr. Shockett. We'll talk about the issues I've identified and ask you to be prepared to discuss with respects to docket 85 and 86. So if you want to come to the podium, please, Mr. Shockett, we'll talk through those issues. The podium? Yes. Okay, sure. So, Mr. Shockett, I noticed dockets 85 and 86 were motions to dismiss counterclaims, and I've ordered you to show cause as to why sanctions shouldn't be imposed on Rule 11 for the filing of those motions, and so I'll allow you to provide me with why you think a sanction shouldn't be imposed, but I've got questions, and so, okay. I'm going to ask you my questions, and then your answers to my questions may cover what it is that you were wanting to say. And if it doesn't, I'm going to give you that opportunity, okay? Thank you, Judge. Sure. Okay, so the problem that I have with these motions from a Rule 11 perspective is that these motions were filed by the plaintiff, Jeremy Hales, who is party to this action, but yet the motions claim to seek a dismissal of counterclaims against you, plaintiff's counsel. Nods head. The motion doesn't cite any case law. The motion has a couple of stray cites to some jurisdictional statutes and one cite to a Rule 13 of the Federal Rules of Civil Procedure. It contains virtually no analysis and doesn't direct me to any authority to support the request that you've made. But more fundamentally, and this is the real question I want to ask, is what basis did you have to believe that Mr. Hales, as the plaintiff, could somehow seek dismissal of a counterclaim that you believe somehow had been brought against you, who is not a party to the action? Thanks, Judge. So we look at it. I don't have it with me, but I know the counterclaims very well. There was no statement of the parties. There was no jurisdictional statement. There were allegations in the complaint. That's the only one left now, and that was the same. That's the same one that still is active. Something about me and my client conspiring. This is under intentional infliction of emotional distress. Correct. That's count one of the counterclaim. So there are allegations against me, and I'm conspiring with my client to do something, and it's a tort which involves outrageousness. You know what the tort is, and then there's the second paragraph, allegations against me, and so I'm being alleged things. There was even no addendum clause. So even if that's right, how can Mr. Hales move to dismiss a counter if you believe that? Right. So how can Mr. Hales, through you, his attorney, move to dismiss a counterclaim brought against another person? Because it was a jurisdictional issue. Because now there's no jurisdictional statement that would have clarified it. Statement of the parties. The addendum clause would have said, I'm suing Jeremy Hales for X number of dollars. There's no addendum. Did you receive, was a motion filed under Rule 13H to add an additional party, which is what's required when you're going to add an additional party by virtue of counterclaim? There was no motion. Okay. On that. Okay. Were you served with the summons in this case? I was not. Okay. And isn't it well established that if you want to name an additional party in a case as a counterclaim party, that you have to serve that party? You would think. I don't know if a summons was coming, but you would think. But so none of those things had happened. And I'll be honest, when I got your motion, because of the way this case has been litigated, I just shook my head as here we go again. I know. Because I read the counterclaim, I read the answer to the counterclaim when it was filed. I didn't see a counterclaim against you. Not said. You filed a motion. You filed several motions previous to that, which were, I think, were motions for summary judgments, which I said should not have been filed. Those motions were on behalf of Mr. Hales, and they were aimed at those counterclaims. And then very soon after I strike those, you filed this motion. And as I said, I looked at it, and I looked at what is he doing. There's no counterclaim against him. And then Deuce responds and says, I didn't bring a counterclaim against him. So from a Rule 11 perspective, what's the legal or factual basis for you to believe that a counterclaim had actually been asserted against you, that you could move to dismiss that counterclaim? Okay, Judge, I just said it. It's you had allegations against someone that's not in the case. Okay. And so why is that appropriate? Why are the allegations against you? Maybe it's not appropriate. Okay. And maybe you file some other type of motion, but you can't. A motion to dismiss a counterclaim presumes that there's a counterclaim. The only way you can bring a counterclaim to add an additional party is file a motion to add an additional party. Serve that additional party. That person is then added to the docket, and that person files a motion to dismiss. I understand, Judge, but I understand. But so the problem here is, this is why I'm so frustrated with this case. I see your frustration and understand. You guys don't appear to understand that I have hundreds of cases, and you too consume an inordinate amount of my time and my staff's time. I know your case number by heart because I have to type orders in that case all the time. What I see is, and you're guilty of it, as is Mr. Manscan, it's just one motion to dismiss. We got first all these motions for summary judgment that get filed. Why are we filing a multitude of motions for summary judgment right after a counterclaim is filed when we know that we're going to have a summary judgment deadline? I strike all of those. Can I be heard on that one, Judge? You can in a minute. I strike all of those. And then right after I strike all of those, here's my next volley of new motions. Then I rule upon those, and here's my next volley of new motions. And I just do not understand what you're trying to accomplish here. If you're trying to pursue a case on behalf of your client to obtain relief for your client, the way that you do that is you go to a trial and we have a jury decide the case. If you look at this case that goes to trial where it has two lawyers who are doing their jobs for your client, there might be 50 docket entries in that case at most. I'm at 125, and they're not even through discovery. And I will also say that I believe it was 75%, if not 95% of those filings were Deuce's filing. And some of that is Deuce's fault. Most of that is Deuce's fault. Some of it's yours, and he's not here, and you are. So tell me, I'm trying to understand why. I know. Or what's the point of filing those motions? What? I really want to respond. Yeah, I'm going to give you an opportunity. If you recall, at the beginning of this case, they did that. And I had to respond to the summary judgment that was filed instamatically. Yep. And so he was trying to say you don't have evidence. You don't know the standard for all this. I know. It's a very high standard. And I denied it. I know you did. But it was allowed. And how was it allowed? I denied it. I denied it. You denied after I responded, Judge. Yeah. And it took a few months to deny it. Okay. So again, It was, and I think you had said maybe on the record or off the record that the chances of something like that being granted are like 99% million. Forget it, against it. But it was done to say you don't have any evidence, and they didn't, and they don't. But you said, and again, those motions are not specifically here. I didn't notice those as part of what you're going to talk about. Right. But I looked at them in preparation for the hearing, and one of the things you say in there is, there are no genuine, of course, there are. I sit here and I look at what is alleged in this case. Your client says that they did these things, and they say that they didn't. But it's a slap. It's an anti-slap defense. Okay. And you've got that motion. That's a separate issue of whether or not this case should be decided at summary judgment stage, right? Okay. We have a factual dispute. There are, and I just don't see any way that summary judgment is going to resolve this case when Mr. Hales said they placed these signs out there. They said these things. They did these things. They say they didn't do those things. That's what we have juries for. So what? It would be in everybody's best interest if we could just get to the point and, well, I don't know what's going to happen to the motion to withdraw, but I can tell you, Judge, and this was from the heart here, your experience with this, and I haven't done the math, but I can almost guarantee you it's a much higher percentage of filings from the other side. There's a lot on which I have to respond to those filings, Judge. When he files something, I have to respond. But I also, there's also attachment into document 117, I don't know. A whole bunch of your emails, pages and pages of them, and I don't like them. I don't like them either, but I would tell you those are excerpts. You don't see the whole emails. Well, that may be true, but I don't like them, and I will never. The emotions that the court is going under, I hope you understand, I'm going under also. But you throughout this, you stir the pot. Okay, please tell me how, Judge. We're in the middle of this lawsuit and you file an amended complaint to sue their lawyer. Nod said, there is no purpose to do that other than to stir the pot and instigate conflict. You knew it wasn't. You knew I wasn't going to allow you to sue their lawyer in an action which they are represented, because there's no way that lawsuit can go forward with that lawyer serving as both lawyer and party. You knew that. There's no way around that. You can't. You can't have a lawsuit go forward where you sue the defense lawyer. The defendants are there, and the jury is supposed to be like, okay, now you're the defense lawyer. Now you're not. Now you're a party. Now you're on the stand. Now you're cross-examining yourself. There's no reason to do that. And it raised all those things, just raised the temperature here. And I thought, when I got assigned this case and read the complaint, I thought this is a simple case. We got one plaintiff, 2 defendants. The case goes forward to trial. And it is ballooned into this nightmare. And maybe it's some of their fault. Maybe it's some of their fault, but it's not my fault. It is not your fault. But you know who deals with all that time? Me. And I'm done with it. I'm done with this gentleman right here. My law clerk spending most of his days researching and writing and trying to keep up with the docket in this case. And he nods his head. Well, because you're not entitled, Mr. Hales is entitled to have a trial in this case, but he is not entitled to monopolize a federal judge's time. There's no doubt about it, Judge. And so you bear responsibility for that. I do. And I appreciate that you're here, and I appreciate that you're acknowledging some responsibility. Let's go back to those 2 specific motions. Okay. And this is a problem I've had with practice in this case overall, is I get motions, I read them, and I say, okay, what cases should I go read? What's the legal? What's the case law in this? Or what? And most of the time I get nothing. I don't have any. Your motion to dismiss, does it direct? Does it cite the 11th Circuit case? Are you talking about this anti-slap? No, I'm talking about the one that we're before right now. The 2, document 85, document 86, the motions to dismiss the counterclaim. Do they cite any 11th Circuit precedent? It's just jurisdictional. It's a jurisdictional argument. You're having to try to add a state, someone from Florida to Florida. Did you discuss all this and how it is that you're actually a party, whether or not any case law about how a person who's not been served yet in a lawsuit is a party to a lawsuit? any case law about how it is that you could have a plaintiff seek dismissal on behalf of somebody who has not actually yet been served. No, Judge, but so who's going to do that? Who's going to do that? Me. You expect, so what you expected to do was file that motion, and then I'm going to have to write an order to go through that and spend time to say, here's the legal standard. Here's what it takes to add an additional party under Rule 13H. Here are the service rules here. And then I'm going to have to provide all the analysis and the discussions to explain why those motions have no basis in fact or law. Okay, I'm getting it now. What was going on? When I'm judge, had there been a statement of the parties, had there been a addendum clause saying I sue Jeremy Hales for X number of dollars, it wouldn't have happened. You had allegations, serious ones, that I'm conspiring with my client. And so just all I needed was an addendum clause. So you think it's surplusage. I don't know what all those allegations are now. Then you can move. There are mechanisms to doing, right? We're going to, that's right. The statement doesn't belong there. But the mechanism is not a motion to dismiss made by Mr. Hales on behalf of his lawyer. I talked to her counsel about this. This is, had there been an addendum clause, I'm being accused of allegation paragraphs and the count of intentional infliction of emotional distress that I'm conspiring with somebody. But it's not. It's not as though this is the only case ever where people who are not sued, they're discussed in a complaint. That happens all the time. There are people who you can have a whole narrative in a complaint about a whole bunch of different conduct by a whole bunch of different people, but the plaintiff has decided to sue two of them. And if the two people who are named as parties and the two people who get served with the complaint, those are the people who are the parties to the action. You don't become a party to an action because somebody uses your name in a complaint. Well, it was the conspiracy thing. And also they just would have had an amendum clause. We sued Jeremy Hales for X number of dollars. Even a statement of the parties, which is required. A jurisdictional statement is required. None of those were there. So, and does your motion address any of those issues? Does it raise those issues? It raises the issue that the jurisdictional argument, you didn't make the statement, so you're accusing someone of a conspiracy. And I'm saying, well, if you have this allegation against me, you can't make it here because I'm a Florida resident. Okay, here's what you said. Defendant Preston filed a counterclaim which seeks to add plaintiff's counsel as a party defendant. Where's that? How do you add a party? How do you add a party? I understand, Judge. And again, if that would have been there, that specific, it doesn't need to be there. I just told you the rule. Right. But he could just file the motion afterwards, right? Isn't it? There's a time deadline here to respond. And you can oppose it. That's what you can. You're right. I can oppose it. That's why this works is if someone wants to add a new party in a counterclaim, they file a motion, they detail that, you can respond and you can say, look, hey, they're trying to add me. They can't do that because it would destroy complete diversity. Right. And then they can reply to that and they can rule on it. And if they want to add me, they got to go to state court. And if they got to serve, they have to serve you and do all those things, none of which happened here. And again, I go back to my basic reaction and the reaction of my chambers, which I read. We read the counterclaim and none of us saw you added as a defendant. Okay, well, Judge, so if it please the court, I'll accept what you say. Whatever you want to do, I will accept it. I mean, you asked me where I was coming from. Yeah, I appreciate. I see the allegation of conspiracy. But again, if this was just those two, if it was just those two things in a vacuum, yeah, but it's not, everything's considered in context. Well, then I wish you would let me, and I wasn't. Yeah, I'm going to let you. I'm going to allow you to say everything you want to say. If you want to look at this later, because I was focused on those two motions today. No, that's what those two motions. Right. I'm talking about those two motions, but I'm saying if those motions arise within the context of the entire lawsuit, absolutely. And the context of the entire lawsuit is is those are kind of the latest in a flurry of, I mean, look at the docket here. Can I show you something that I was going to show you? Sure. I mean, the document cam is right there, but let me finish here. Okay. And then I'll give you an opportunity, but you've got to consider that. I mean, look at the docket here. And I don't know, maybe you aren't on ECF all day long, but I am. Yes, Your Honor. An objective observer would take a look at this docket and say, what a disaster. I agree, but I have done the math. There's a lot of stricken besides things that you have filed. Excuse me? There's a lot of bold stricken besides a lot of things that you have filed that I have stricken for for example, you filed an answer and a Rule 12b motion to dismiss. And there's a reason for that, but you can't do it. You can't do it. Okay. Rule 12b motion has to be filed before the answer. I have something to say about that if I could. No, I'm not interested in hearing your explanation because I'm telling you, I'm not sanctioning you for that. I'm telling you can't do that. Okay. And so that's just an example of how this docket, everything just gets ballooned. And what any reasonable observer of the docket would also say is, I have been way too patient. And probably the reason why the docket has gotten the way it is I've given you guys too much leeway. And look, I've never had a situation before where I threaten people with sanctions and they don't stop. Well, your threats were taken very seriously. Well, here we are. Well, your motion that started this one said, do not name call, and you won't find one example. Yeah, but you do a lot of me doing that. But you do a lot of threatening of getting me involved and I mean, the emails attached to that one document, I don't like any of them. I also tell him, please, please, please don't disparage people. Yeah. I say, please don't do this. I'm trying, Judge, to educate my friend who's a member of the bar in Connecticut and Massachusetts. I'm trying to educate him. Please, this is not proper. I could show you a lot of emails. You're not seeing them. Well, I'm sure of that. I believe it. Most of them are teaching emails for me, teachable moments. Right. Well, some of the stuff, this is not let me read you one. This is not a teachable email. Okay. Okay, wow, you really obviously don't know how to research. I do know the cases, and since you are not even licensed to practice law in Florida, I don't think it is my responsibility to tell you the cases, but you might want to start with the Supreme Court of Florida on this exact point. That is it. I'm not going to do your research for you. You are 1,000%, 1,000,000% wrong on this. Just asking you, this is counterintuitively. I will ask you a rhetorical question. Why do you think the 21 days is there if it doesn't have any effect? Check that out with the Supreme Court of Florida. That's a teaching email. He sent me law, which is wrong. It's almost like saying Plessy versus Ferguson is valid law. That was the context. Okay. And I'm not saying no, Brown versus Board of Education overruled it. That's your idea of a teaching email. If you saw the string, Judge, look, I think I said this to you guys before. This is like talking to my kids. Yes, when my 11-year-old does something, then my 7-year-old reacts, and my 7-year-old reacts and says, well, look, my 11, he did it first. Yeah. I mean, do you have children? 3. And when they do that, do you say, oh yeah, it's okay. It's totally cool that you did that because they did it earlier. No, but that's what you want me to do is say, look, yeah, I see that you did these things, but someone else did these things first. That's what we're supposed. I mean, you wouldn't accept it from your children. I wouldn't accept it from mine, but you want me to accept it from you. I don't. And if he's going to be withdraw, Judge, please give me a second chance. I've already done that. Okay. I sat here and did a redeposition, 2.5 hours of my life that I will not get back because you guys couldn't do a deposition on your own. Well, we've taken some now that haven't had any issues. So good. Yeah. But let me just, while I've got you here, and I know you're getting beat up on because the other person is not here. That's fine. But the Mr. Paget thing, you tell me you move to say you didn't confer with, they didn't confer with me. Deny the motion. I did because they didn't satisfy the meet and confer requirement. But then I look back and there had been this discussion about scheduling a deposition. And then it's like, now we're not. But I give them dates. I said, we're available this day. Yeah, I know. That's what I'm saying is that. But it looks like you're not assisting at all in helping to conduct the deposition. I'm just using that as an example. Right. where, all I'm trying to get you to see, Mr. Shockett, is I've got lots of cases. And almost all those cases, lawyers have to deal with the same, they have to deal with the same type of requirements. They have to depose people. They have to do all the things, and I don't want to hear about it. I assure you, Your Honor, there's lots of things that you haven't heard about. Yeah, but I'm saying those lawyers, they figure it out. I can figure it out with anyone else, Judge. And the stuff I wanted to show you. Yeah, you'll get a chance. But what I'm saying, though, is if you think it's going to get easier now that there's a pro se party, potentially pro se parties involved, I don't know that it's necessarily true. And so I think you've got to figure out a way that you can't keep filing stuff like those motions, because that affects the court. That affects the resources you're using, the resources of the court. And I'm looking at a motion to dismiss counterclaims going there. There are no counterclaims. There are no counterclaims. He's not been served. There's no motion to add him as a party. Why is he filing 2 motions to dismiss? Well, there are duplicates, but yeah. And they don't have to be filed that way. You can file 1 motion on behalf of both as it relates to both defendants. And I'm just trying to figure out that it's just an example we have before us. Just no need to do it. And I agree, Judge. And when I sit back here, and I'm not involved in everything that you are, when I sit back here and I look at the docket and I see this stuff happening, and I see that those 2 motions come in with no factual or legal basis. I see others come in from the other side with no factual or legal basis. And then I see others come in from this side, and it just looks like, I get it. So go ahead now and show me what you want to show me. But we can turn the document camera, or you can give them to the clerk. Well, I'll show you, but it's at the risk of it's almost like a moot point. But yeah, I'll show it to you because you don't have it. Okay. I was going to bring it out. So I'm giving this your opportunity, whatever you want to show. Well, it doesn't relate to those dismissals, but yeah. So if you notice from Mr. Manskin, you can use that right here. Would you like to use the document camera, or would you? Sure. You would be able to put it right there. What are you going to see? Maybe I don't. What's that? What you're about to see, maybe I don't want to publish it, but you'll see. Is it face up? It comes to me. So face up. Yes. I can't see. Maybe you can. Can you see the whole thing now? Yeah, I can see it. So if you noticed in the items was one which he didn't respond to Deuce about Clownsel. It was not a typo. This is one example of, and it's on Facebook. He routinely in our phone calls would say, Clownsel, are you available? Here's another one. Here's a picture on this. You can Google this. Yeah. They have one with this polyflop, which is not an acronym that anyone knows about, with me wearing a crown. And they took it down after you set this hearing. Here's another one. This is a Clownsel, an email that you didn't see. And he also attacks my client, calling him an extremely petty person. And I want this case heard, Judge. And I can tell you that this is only a sampling of what's out there, though it's not focusing. Right. There's a little focus thing on the top. It's like a little knob. Yes. Right there. That will focus it. We're in. Okay. This was before August 3rd. I want to destroy this man and his YouTube empire. That is the goal. Destroy Jeremy Hales legally. I'm giving you like a coming attraction of a movie. Yeah. And what out there. And he's also saying he wants to take my deposition. So when the counterclaim came, I go, okay, now I see his conspiracy. Yeah, I'm going to deal with all of that. I wish you would, Judge. I really wish you would deal with all of this. Still haven't. I apologize to the court if I reacted like I'm being accused of something. But part of it, like what I'm trying to get you to see, because I'm removed from your daily interactions, and it's just sometimes when you're involved in something, you don't see it the same way as some neutral party who is not privy to all of it, that sees it right, you see something different. And what I see is tit for tat, and what I see is you sue him, then he says nasty stuff about you, but there's you naming him as trying to file an amended complaint that named him as well. You actually did name it as a party amended complaint. Do you see how that looks? Judge, let me ask you a question just rhetorically. Can a client use their attorney, especially in a defamation case, in a tortious interference case, to continually to defame and tortiously interfere? Yeah, well, I think that's why you can have another action. Okay. but I was trying to combine them. Yeah, but, and you saw, I hope you saw the email to whatnot. Yeah. And again, I'm not getting all that. I'm just trying to get you to see what it looks like. I do see what it looks like. You have no idea, Judge. Please understand. I understand. I understand. Yeah, yeah. And half these sockets are my responses to him. Yeah. And I understand that that's what you asked me, what I was thinking about. Yeah. I will give you context. I see a conspiracy. I see someone want to take my deposition around the same time. Still, even 2 days, 3 days ago before this happened, asking me for deposition dates. Yeah. So my responsibility here is my responsibility is to first ensure that litigants in a case get their opportunity to have their case tried in front of a fair and impartial tribunal, right? That's what we're trying to do here. Yes. I have an obligation to make sure that the judicial system is not abused and that the resources of the court are not unnecessarily diverted to frivolous and malicious and unnecessary litigation. And I also have an obligation to ensure that officers of the court behave appropriately and don't abuse the privilege that they've been given to appear in front of the court and to litigate cases in federal court. That's not a right, it's a privilege. And I've just really struggled here because I've been on the bench for, a little over 2 years, and I've been a lawyer for about 18 in a lot of different contexts. And I've never seen anything like this. And so maybe you haven't either. I don't know. Mr. Shockett, I haven't. But you do bear some responsibility for it. I do. And if what you want here is for this case to go forward and for this case to go to trial, then you're responsible for your conduct. You're responsible for how you respond to somebody else. Yes. And you're responsible for what you push send on, and you're responsible for what documents you file. And my assessment at this point is that you haven't exercised that responsibly. And I'm not saying that this isn't a comparatively negligent type situation where assigned degrees of fault, right? But I want you to understand that I'm not pleased, and I've said that before, but today is the day that, sanctions are going to be imposed, and if it continues, they will continue to be imposed. It won't, Judge. It won't. Well, you got this other litigation going on too, Judge. Did you see that one, by the way? Attorney Gage, he and I are just as professional as can be. Yeah, we confer. Hope that maintains. I hope that continues, but of course it is. Of course it will. I see you disagree, but I have to tell you, yeah, Judge, if you looked at me, I'm not going to be filing motions against pro se parties. Like anything like this. And I wanted to say this because you used the word yesterday, absurd. I've used that word in emails. To his sometimes allegations or comments. So when you said that, what's the word I have used? You haven't seen the emails. It is you already ruled. I respect that. But again, I'm saying though, you don't have to do things like sue him, try to amend the complaint to sue him in this case. I mean, that any rational lawyer in that situation is going to react negatively to that. But you're representing your client, Judge. I mean, you can file another lawsuit. We did that. Yes, but after I told you no, which you knew was going to happen. As I remember, Judge, you said, would you like that to happen if you were are the other lawyer? Yeah, I said no. And I'm sure if someone did it, that you may have unkind things to say. I mean, what? Sorry, I didn't hear. You may have unkind things to say if someone tried to do that to you, right? And so there's responsibility. We could have litigated this entire case without that. And all that did was ratchet the temperature way up. And going forward, whether you are litigating in this case against Ms. Preston, Mr. Cook proceeding pro se, or whether they have counsel who comes in, my expectation is that your motions are supported by citations to case law, contain analysis to help you resolve the issue presented, and have a basis in fact and law, and are not filed because you have an emotional reaction to what you think someone else is trying to do, but instead you step back and say, well, they can't. They haven't added me as a party. They haven't moved to do this. I haven't been served. I don't have any basis to file this motion to bother the judge with these motions. I hear what you're saying, Judge. Okay, what else do you want to say? This is your opportunity. We do have, obviously I said I have no further motions until this hearing. I have a very lengthy discovery motion that I've been sitting on. Actually was going to file that next day. Yeah. I need to file it. I don't know where we are with, well, there's a pending motion on to withdraw, right? So I said, and I haven't ruled on that. So the likelihood is that there will be a stay in this case anyway. Okay. But the counsel will have to be obtained for the other side. So should I wait till the stay, or should I stay, or should I go? I had to resubscribe. No notifications. No, Reen. Irene, that sucks. Absolutely sucks. You should have got notifications. Don't worry, we're getting to something really good that's going to be coming up. It's going to be coming up soon. Mm-hmm. Right, I'm ready to file, like with a push of a button. Better be good. Basically, it's just them conferring back and forth. Okay, so the court rules, I find no factual legal basis for them, but I've explained there's no legal basis filed against you. So I find that for it, sanctions are going to be imposed are personal to you. I understand they're not sanctions on Mr. Hales. It wasn't his decision to file this motion, so it was yours, and so the sanctions are going to be imposed upon you. It's going to be $2,000 per motion, and it's $4,000 sanction payable to the clerk of the U.S. District Court. You should pay that as soon as you can. If you can pay it today, great. Go down and pay it. If you need more time, let me know. I can see that I actually brought my checkbook. I couldn't bring my laptop. Okay, all right. So yeah, so it's in my briefcase. You can take care of it. Nods head. I've sanctioned a pro se party under Rule 11. I've issued attorney's fees under the mandatory attorney fees provision. The discovery rules never sanction a lawyer. Under Rule 11, I've never had a show cause hearing to sanction lawyers. I don't want to do it. Recognize, blah, blah, blah. I can tell you that I'm relieved. What about it? Doesn't make sense. That's what I want. Brief question. I'm sorry, I'm reading really fast. So if it looks like I'm scrolling fast, I'm actually reading it. I just want to see if there's anything else in here. Got a rule on this motion withdrawal. I haven't granted it yet. All the orders, some of this coming. Wait, yes, no. Stay. Okay. Once that is relieved of the responsibilities as counsel and they're pro se, you shouldn't do it. And I issue a stay that nothing happens for 30 days until she gets counsel, including talking to her, conferring about anything else, right? Case is going to be stayed. So that means the motion, I shouldn't file it because I was just talking about him. So it's fine. Just as long as you know. All right. So that's just where he's holding off the stay. And then it was concluded at 1:49 p.m. Yeah. Oh, cancel that. Let me go ahead back to this one here. All right, I've got another one I want to show you guys because this one's pretty good. I hope you're ready for it. Yeah, YouTube unsubscribed me a few channels I watch. Yeah, it does that sometimes. YouTube is asshole. All right, let me find it here real quick. I thought I had it pulled up, but of course, as usual, I don't. And is it? It is right here and right there. You guys are gonna love this one. Wait till you see. Wait till you see this one. All right. You remember, I told you a little while back that there were some attorneys, Chips, and a couple of other attorneys are representing some plaintiffs. Okay. We had a judge make a 50-page order telling him, yeah, you're going to get sanctioned for this. I'm dismissing the case. Sanctions are coming. It's dismissed with prejudice. There's appeals that are happening currently on that dismissal. Doug, rewatch Late Ray. Don't you worry about it, Mama Bear. So, Chips. Chips is not out of hot water yet. Neither are his cohorts. Neither are his cohorts. they are in a world of fun, I guess is the best way to put it. So let's bring that up. This right here is ordered confirming the continuing appearance of attorneys Hunker, Paxton, and Federigos. 3 attorneys of record have appeared for the plaintiffs in this action. Thomas L. Hunker, Virginia Ashley Paxton, Michael Federigos. The order of January 5th, 2026 noted that all 3 were attorneys of record. The order denied without prejudice the motion of Mr. Hunker and Ms. Paxton for leave to withdraw. That motion had asserted that they were the only attorneys of record for plaintiffs, overlooking Mr. Federigos' appearance. On January 5th of 2026, the plaintiffs and each of the 3 attorneys of record were ordered to take a specific action. By January 20th, the plaintiffs must file a notice stating whether Mr. Federigos is still representing them in this action, and if not, when and how the representation ended. The notice must be filed by an attorney of record for the plaintiffs, and if any attorney of record disagrees with the filing, that attorney of record must file by January 27th, 2026, a notice stating that attorney's position. Each attorney of record is responsible for filing the initial notice, but if one notice has been filed, an attorney who agrees with it need not file another notice. Guess what? No notice was filed by January 20th. Nobody said shit. Nobody did shit. They just let it go. And no notice setting out any disagreement was filed by January 27th. Well, each attorney's failure to file a notice as required or to ensure that another attorney of record did so was I'm not even going to try to say it, or nearly so. The attorneys should note well, compliance with the governing rules and court orders is mandatory. Any further departure from the rules or any order is likely to result in sanctions and a referral to the Florida bar. It is ordered Mr. Hunker, Miss Paxton, and Mr. Chips each remain an attorney of record for the plaintiffs in this action, so ordered on January 27th, 2026. Judge Robert L. Hinkle, United States District Judge. This right here is a judge that is not very happy with Chips at all. Matter of fact, I would venture to say he's pretty pissed off at Chips right now. He's already written a 50-page order on how he should be filing shotgun pleading. And I would almost venture to say that whenever this hits the appeal, in this case, because it is under appeal right now, when it hits this appeal, that's going to look really, really bad on all of them for filing an appeal. Boy, oh boy. But I guess they're more worried about their marriage over there than putting on makeup and all that neat stuff. Well, they do whatever they want to. If they want to, make that little boy up, go for it. Me too. Since 3:30, no worries. I appreciate the acknowledgement. It's good to see everyone in here, though. So, tomorrow I might take a little bit of a break away. It is coming up on what, the 28th? Yeah, it'll be the 28th tomorrow. I might just take the night off. I don't know. I'm feeling, my throat's not doing like it's supposed to be doing. But I like hanging out with you guys so much. That's the fun part. Is like, man, I just like hanging out with you guys because you're so much fun. Chat goes crazy. You just listen to me randomly reading all kinds of crazy stuff. So maybe tomorrow we'll just, I know what we could do. We could do a nice little bit of some crazy court watches. How does that sound to you guys? Would you like to see just some crazy court watches tomorrow? That make you want to come by, hang out, watch a crazy court watch? Now, of course, if you need some lemon tea, no. It's beyond the lemon tea. It's beyond the lemon tea. It is, these peeps are crazy. Yeah, these peeps are crazy. We've got tons and tons of stuff, but I need something that I can just rest my voice for an evening and not have to keep up for like, 2 hours doing this. Because it's rough. Like I can start to feel it right here. But I will say that I still want to hang out over here, have a little bit of fun, do a stream with music or court things. That's what I'm thinking. Just do some antibiotics. No. What it'll be gone by the time the cold weather goes away. Yeah, that's the bad part about it. I've got the time to do the streams. I just don't have the voice for it right now. And as it gets warmer, I'm going to have less time to do streams. I'm going to have to really change up my schedule quite a bit. And that's just because I'll be doing all other kinds of work. And I'll probably be really damned exhausted coming on here. That's how it usually works out. But I do, yeah. Thank you, Teresa. I hope everyone else is also having a wonderful night too. But like I said, we've got some stuff that's going to be popping off here shortly. February is going to get crazy. We've got lots of court documents that are coming up. You've got the fleas over there and all their cohorts threatening Travis. They're threatening violence on people. It's just like there's so much you're just sitting there going, why is it a crock pot of chicken soup and make music? Yeah, that would probably work. I do have some new stuff that I've been working on, quite interesting. I do have one. I don't know if I played it. Have I played it yet for you guys? Let me see. I think I probably haven't. It is, and now Mo and I usually do Fridays. We didn't do last Friday because there was a winter storm that hit, in case everybody didn't notice. The hoarser you get, the sexier the voice, though, right? I don't know about that, Mama Bear. It might be to somebody, maybe my wife. She might think it's good. I was messing with Roseman's Ranch today. She was fun. I like giving her a hard time. Oh, nope. Oof, got it. Ooh, I almost ended the stream right there. Give me a second. Pull this up on another screen so I can show you this song. And Mo had on Fridays, Mo and I, we usually work on putting some music together. And it turns out pretty good sometimes. Let me see if I've got the one for her, because she was talking about, being locked down in the cold. And I thought it was a good song. She said, I just need a whole bunch of boxed wine. And I said, well, I think that should be a song. So I did make a song called More Boxed Wine. I hope you guys like it. It's going to be, it's a fun song. And I'm going to get it up here for you shortly and do this. And where is it? Add to scene. Okay, there we go. And do this. And I'll give you the boxed wine song. All right, here we go.
Storm winds howl like wolves at the door. Pantry bare as a beggar's bowl. Heart fire low.
One mother's war cry echoes through the halls. Eyes wide with shadows as the last drop falls. She grips the box like a desperate prayer, shakes it to summon ghosts from the empty air. Children swarm like demons in robes. Toys scatter ruins, this is life indoors. The hearth mocks with flickering deceit. Shovel buried deep, serenity and retreat. Kids bouncing off drywall like feral raccoons on Red Bull. Candles gutter out, she can't send them to school. The cold whispers curses through the frosted pane. Yoga pants stretched to breaking, her tears show the pain. No vino, no vodka, it's a mommy's and meltdown. Box wine tap, dry screaming in a nightgown. Cold hands, hot takes, tantrums by the case. Welcome to the blizzard, care and hydrate your rage. Cul-de-sac turn, slip and slide, a shame and regret. SUVs iced in place, cursing the plows dead. Casserole drama trending, Facebook on life support. Share if you're freezing, Susan, go hug the porch. Freezer clicks off like a cruel punchline joke. Pop-Tarts now, crypto trading for a warm coat. Pinterest dreams, soggy kids counting moms. Freak out stats, learning fractions by how many times she snaps. Wicks burn low as vigils for the lost in the day. Tantrums by the case. Welcome to the blizzard, care and hydrate your rage. Why is it so quiet? Yeah, right, in this screaming house. I paid for unlimited. Storm don't care about your spouse. Back in my day. Okay, boomer frostbite king. The blizzard just shrugged in nature, everything. Yeah, neighborhood watch pacing like zombies on no sleep. Trading tea lights for tiny nips, black market creeps. Snow angels with tear tracks, frozen like chains. Shields sell a soul for a spits and warmth in her veins. Power flickers, hope spikes, then ghost out again. Journaling rage on notes app, blaming the polar vortex. Men therapy, Zoom canceled. Coping skills, repo quick. Breathing apps drowned by the shrieking kid click. Drain the box, rattle the bones, sever the seal, breathe in the void, murmur, endure the grind. No vino, no vodka, it's a mommy's and meltdown. Box wine tap, dry screaming in her nightgown. Cold hands, hot takes, tantrums by the case. Welcome to the blizzard, care and hydrate your rage. When the power creeps back and DoorDash revives, she'll post a glow up like the meltdown never thrives.
I don't know, Jimmy.
The empty box remembers every scream and plea. The empty box remembers every scream and plea. The empty box remembers every scream and plea. Welcome to the blizzard, care and hydrate your rage. When the power creeps back and DoorDash revives, she'll post the glow up like the meltdown never thrived. The empty box remembers every scream and plea. Welcome to the blizzard, care and hydrate your rage.
Look icon she uses usually flipping the bird, not snapping fingers. But I love it anyway. I like this one. Yeah, that was a fun one to make. It was Mo comes up with really great ideas for music. You know, I just put it all together. Just put it all together. Give it a little bit of music. Like there was one about, what's it about? I think it's about cats. Let me see. Is this the right one? Yeah. Oh yeah. Yeah, that one was about cats. But I'm not going to play that one. It's about a lady had two cats in India, and those two cats, this guy had to pay child support for the two cats until they passed. Could you imagine that, having to pay for? You get into divorce and she's not asking for alimony, she's asking for money. Can you imagine that? Saying, hey, I want money. And they give it to her. Oh, it's so bad. So bad. I can play it.
Roses aboard.
When Buzzes up, boy. We split the sheets, no fight, no screams. Just signed the papers, killed the dreams. She kept the house, the bed, the keys. But the real prize, those two pussies. I didn't fight for custody, no sir. Let her have them both, that's how it worked. But every quarter like clockwork, damn. I got her sent 10,000, keep them fed and pampered, man. Buzzes up, bark. Yeah, I'm paying that bill, 10 grand every 3 months, what a thrill. She got full custody, I just get the tab for 2 hungry little pussies that I used to grab. Buzzes up, bark. CPI gon' make it rise, inflation hitting harder than between her thighs. 10 years minimum until they cross that bridge, I'm still financing, pussy ain't that a bitch. No alimony, no, I don't have your shit. We kept it civil, didn't throw no fits. But those two hairy things got by, got me on a monthly leash. Wonder why she texts me receipts for the fancy feast. Toys with feathers, catnip at least. Laser pointer, scratching post deluxe. While I'm out here broke, missing that puss. Pussy's a bark, yeah, I'm paying that bill. Quarterly deposits, I get no thrill. She strokes them daily, I just get the charge. 2 furry monsters running up my car. Index every year, digits saying more, bringing me to tears. I thought the marriage died, but not surprised. I'm still getting milk by them bedroom eyes. They say in Turkey there's a brand new thing. Pet alimony, let the lawyers sing. But we both know the truth, don't need no proof. This ain't about the kitty, it's about that poof. She got the warm laps, the midnight knees. I got Venmo notifications by blue balls fees. So here's to the pussies that won the war. I'm out here broke, still begging for more. Pussy's a board, yeah, I'm playing the game. Quarterly tribute in your pussy's name. No visitation, no weekend pass. Just endless payments for that sweet, sweet ass. Till the last cat croaks. So 10 years past, it never hurts the most. So raise your glass to the divorce decree that turned that pussy into lifetime fees. Pussy's a board. Pussy's a board. Pussy's a board.
See, don't worry. It's not a dirty song. It's just about paying. Yeah, they were pretty great cats, I guess. But she was like, I want alimony for the cats. And that's what she got. Ooh, flipping birds on stream. Here, I've been flipping birds on 3. No, I wasn't writing anything dirty. I wasn't writing anything dirty. It was about cats. Putty cats. See, people take things the wrong way. Take it too literally. You can't take it too literally. Yeah, it was 10,000 whatever Turkish dollars, which ends up being something like $230 quarterly or something like that. Paying for all their toys, their catnips, and all that kind of stuff. I mean, and that, if the cats get sick, he had to pay for that too. It's just like, man. So awful. So awful. Well, I'm going to send you guys over to MG Law. Show him a little bit of love. I think he's streaming tonight. You better be, because that's where I'm sending you guys after we end tonight. Thank you guys for coming by. Oh, she was? Oh, well, might have been. But everybody have a wonderful, wonderful evening. And I will see you guys on the flip side. Thank you very much for coming by tonight. See you soon. Peace.
Thought I was done, bless your heart. But I'm still living rent-free, it's a work of art. Call me daddy, call me Papa Nut, call me the GOAT. You're paddling upstream while I'm running this boat. You say, I don't care, yet you're glued to the screen. Bathe in my glow, you're so unclean. Your shade like a breeze, it's barely a draft. I'm the Picasso of roasting your ass. You say you're over me, oh how cute. But here I am, still the star of your loop. You're my biggest fans, don't even deny. So grab some popcorn when daddy goes live, 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 live. Call me daddy, daddy, daddy. Yeah, shout it loud. You're a mental midget while I stand proud. Papa Nut, Shizzy, daddy, headline act. Your background noise and it's just a fact. Call me daddy, daddy. Let's face the score. You hate that you love me, but you keep wanting more. You're like a dog chasing racing cars, you don't know why. But here you are, barking while I touch the sky. Your comments are gold, such comedy gold. Who hurt you? Oh wait, it's me, I'm told. You're keeping tabs like an unpaid intern while I'm cashing checks. When will you learn? Your timeline's a shrine to every move I make. I'd say thanks, but you're a nasty skank. Oh, Shizzy's washed up. Yeah, sure, Jan, yet here I am, the centerpiece of your plan. You hate, watch my stream every damn night. That's why, kiddos, I'm still shining bright. Call me daddy, sending your bread. I'm living rent-free in your effing head. Popping nuts, Shizzy daddy on your brain. I'm your mental landlord, you wanna complain. Call me daddy, let's keep it real. You hate that I'm winning, but you love how it feels. Oh, I'm sorry that I break your streak. You tried to ignore me for like half a week, but daddy's too spicy, you can't look away. I'm the train wreck you need every single day. So while you're out there and you're trying to chase cloud, I'm here sipping coffee watching you freak out. You're irrelevant, wow, what a take. Now go rewatch my vids and I count how much I make. Call me daddy, yeah, own it now. I'm rent free your brain and you don't know how. Pop a nut, Shizzy daddy, let's set the bar. I'm bigger than life, you're a burned out star. Call me daddy, embrace your role, 'cause I'm the main character, you're just a troll. So here's your bedtime story, kids, sweet and snug. Shizzy daddy's forever if you're stuck in the mud. Now say goodnight to Papa Nut, your mental king. Oh wait, you will see me tomorrow, same obsession, same thing. Call me daddy, yeah, own it now. I'm rent free your brain and you don't know how. Papa Nut, Shizzy daddy, let's set the bar. I'm bigger than life, you're a burned out star. Call me daddy, embrace your role, 'cause I'm the main character, you're just an old raggedy ass burned out troll. So that's your bedtime story, kids tucked in sweet and snug. Shizzy daddy's forever, you lose and you're stuck in the mud. Now say goodnight to Papa Nut, your mental king. Oh wait, you will see me tomorrow, same obsession, same effing thing.